Good evening, and welcome to the New York University School of Law Institute of Judicial Administration's 25th Annual William J. Brennan Lecture on State Courts and Social Justice. My name is Tom Phillips, and I'm a member of the IJA Board of Advisors and also a former judicial colleague of tonight's lecturer, Texas Chief Justice Nathan Hecht. We are honored that so many students, academicians, judges, attorneys, and friends of NYU and the administration of justice have come together tonight for what promises to be a very interesting program. The Institute of Judicial Administration was founded here at NYU in 1952. Among other initiatives, it sponsors a week-long program for new appellate judges in July that is now been going on for more than 60 years consecutively. And for more than 2 decades, it has co-sponsored the Employment Law Workshop for federal trial and appellate judges. The Brennan Lecture is another long-running initiative. It started as a joint project with the Brennan Center, but is now exclusively run by IJA. It came up at the initiative of Chief Judge Judith Kaye, leaning on Dean John Sexton. For those of you who remember Judge Kaye, she was a formidable instigator indeed. We have many distinguished guests with us tonight. If I start trying to introduce them, I will really mess up. So I'm going to hold this to a minimum. And if you feel like you should be introduced, stand up when I'm finished. First is the Dean of the NYU School of Law, Trevor Morrison. Dean is here somewhere. There's a lot of directors of IJA. There's 3 faculty liaison directors, Professor Oscar Chase, Sam Estreicher, and Troy McKenzie. And this group doesn't change very much either, and thank you for being here. It was the group when I was in the new judges program. So anyway, the executive director, Torrey Whitman, is here, and his deputy, Allison Scafini. And thank you all so much for all you've done to make this evening happen. The Brennan Lecture is given by a state judge with something to say, and it's good that they have that as the choice for who to ask to give this lecture, because each lecture is published with suitable footnotes by the New York University Law Review. It is named in honor of Justice William J. Brennan, who shares some traits with our speaker tonight. Like Chief Justice Hecht, Justice Brennan thought deeply about the interface between our dual court system and federalism, where both state and federal courts each apply each other's law to interpret and decide cases. Justice Brennan and Justice Hecht have both seen the judiciary from many perspectives, both served in the state courts as a trial judge, an intermediate appellate court judge, and a Supreme Court justice, and then Justice Brennan did something else at the end of his career, Nathan. Justice Hecht started even earlier than Justice Brennan. He began his career when he, at the age of 32, was appointed as a general jurisdiction Dallas County trial court judge, giving preference by legislative instruction to civil cases. He quickly gained a statewide reputation for intelligence, dignity, and integrity, and after winning 2 contested elections, he was appointed to the Intermediate Appellate Court in 1986. In 1988, Justice Hecht won election to the Texas Supreme Court in one of the most memorable elections in Texas history, running against an entrenched opponent who outspent him by more than 4-1. Justice Hecht relied on a cadre of friends, mainly those from his church, to call billboard owners all across the state and find cheap ones on which he could plaster his slogan, "Hecht Yes." Attacking a court that had been pilloried on the 60-minute episodes Justice for Sale and had been lambasted in the New York Times as dispensing for what passes for justice in small Latin American countries run by colonels in mirrored sunglasses, Hecht won the endorsement of every major newspaper, carried the State Bar of Texas bar poll, and stunned political observers by using all that to actually win a race for the Texas Supreme Court. He became only the second Republican in history to win a statewide race against an elected Democratic incumbent, following Governor Bill Clements, who did that feat 2 years earlier, but then Clements had already been governor once, so he had a bit of an easier role. On the court, Justice Hecht won a reputation as an indefatigable worker, an incisive and entertaining writer, and a leading advocate of procedural and structural reform. As the court's liaison to the Texas Rules Advisory Committee, now for more than 3 decades, he has worked tirelessly to make civil trial and appellate procedure fairer and simpler. His work in modernizing Texas's pretrial rules won national acclaim, so much so that Chief Justice Rehnquist appointed him to the Federal Civil Rules Advisory Committee, appointments generally reserved only for a few Chief Justices of state courts. As liaison to the court's Access to Justice initiatives, his strong conservative principles made him uniquely able to explain to Republican legislators in a majority in Austin and Washington why equal justice for all could not be achieved unless everyone had access to basic legal services. More recently, working with the blessing of the presiding judge of Texas' other Supreme Court, the Court of Criminal Appeals, he has become a strong national advocate for criminal justice reform, particularly in abolishing money bail for nonviolent misdemeanor offenders and ending the school-to-prison pipeline. His upcoming service as president of the Conference of Chief Justices in 2020 to 2021, contingent only on the will of the voters of Texas, will give him an even larger platform for working on all these initiatives. To understand Chief Justice Hecht's commitment to the rule of law, one must peruse at least some of the polished written gems that are his work of 3 decades of opinions on the court. From a wealth of material, I would like to close with excerpts from one recent case where the court majority exercised at excruciating length to explain the meaning of the term the plaintiff, as it was used in a Texas statute. Dissenting from both the holding and from the court's approach to reaching its holding, Justice Hecht explained in part, though the court is trying to adhere to statutory text, whatever the result, it opens itself to the criticism that its analysis is picky and detached from reality. Intending to be careful, the court risks being viewed as conducting a contest among the Pharisees in the temple of textualism over who is the most devout. The judiciary's sole objective in interpreting statutes is to give effect to the legislature's intent expressed in its words. Out of respect for the legislative branch, we must read their words in the way they have written them to make sense. The judiciary is not, in my view, entitled to insist that the legislature write for our approval. Our objective in interpreting statutes is to find the legislature's intent in the words it used, not to find what a group of grammarians and researchers might have intended by these words. This does not justify substituting our meaning for the legislature's, of course, or what we might consider desirable politics for those it has chosen. But proper statutory interpretation does require us to give careful consideration to the reality in which and for which the legislature acted. For legislators, each statute has a purpose, which is the context in which the words speak. When we can find that purpose without inventing it and pursue it without adding or detracting from it, it should inform our interpretation. Ladies and gentlemen, I present to you my friend Nathan Hecht to speak on judicial independence, what it is and how we keep it. Good luck.
Thanks very much, Tom. Tom and I have gone back and forth over the years. In July of 1981, one of my law partners said to me, "You won't believe who's about to be appointed to the bench, Tom Phillips." Well, I didn't believe it. It wasn't that Tom wasn't qualified. He was, but he was only 31 years old, 2 months younger than I was at that point. And a couple of weeks later, I was still trying to get in my mind calling him Your Honor, when out of the blue, the governor's office called me. And on September 1st, I joined Tom on the Texas District Court. A little over 6 years later, Tom was appointed Chief Justice of the Texas Supreme Court, and he had to run for election in 1988. He talked me into running with him for justice, and lo and behold, we both won, which surprised me a great deal. I don't know if it surprised Tom or not. So I got to call him Chief until he retired in 2004, and now the shoe is on the other foot. He gave the 8th annual Brennan Lecture, and now here I am, where so many of my state court heroes have stood, including Chief Judge Janet DeFiore, who's here tonight. Tom is a great friend, and I've met so many people that I haven't seen in a while here this evening, and I look forward to being with you tonight. It's personally gratifying for me that the invitation to speak came from my friends Sam Stryker, whose efforts to improve access to justice for the poor I greatly admire and have tried to assist as I could, and Troy McKenzie, who's part of the class of 2017 ALI Council group, and so it's good to see him tonight as well. And I've only just met Professor Chase, but I'm glad he went along with Sam and Troy. Though the invitation came out of the blue, I had no hesitation in deciding to speak on judicial independence. I had just been reading of the president's many denunciations of the judiciary, accusing courts of usurping power and judges of being politically motivated, warning of judicial tyranny and undermining the Constitution, and then going to the extreme of calling for the impeachment of Supreme Court Justice Samuel Chase. I was reading Chief Justice Rehnquist's book, Grand Inquists, which recounts the Senate trial of Justice Chase. And the president of whom I speak was, of course, President Thomas Jefferson. He deplored the thought of judicial independence. The Constitution, he wrote, is a mere thing of wax in the hands of the judiciary, which they may twist and shape into any form they please. What a great tweet that would have made. Jefferson believed judges were no less immune from ambition and influence than other holders of power, and he wanted them to be directly answerable to the people, elected just like other officials. Jefferson makes President Trump look wishy-washy on the subject. President Trump has only called Justice Ginsburg incompetent. He hasn't yet called for her impeachment. He said loudly and often that courts are unwise, embarrassing, dangerous, and political. But surely that's well shy of Jefferson's view of judges as usurpers and tyrants. Both President Trump and President Jefferson have been much more outspoken than, say, President Obama, who in his State of the Union, with members of the Supreme Court sitting directly in front of him, criticized their Citizens United case to their faces. But that was only one case. President Clinton called Judge Harold Bayer's suppression of evidence in a prominent drug case here in New York grievously wrong, quote unquote, but he quickly backtracked and reaffirmed his belief in the independence of the judiciary. If any president opposed judicial independence more than President Jefferson, surely it was FDR, who tried to pack the Supreme Court with justices who would vote his way in New Deal cases. I come as no apologist. When I asked my friend Sam Issacharoff what I should talk about tonight, he said, just remember, we're liberal here. So I wish Tom had toned down all that Republican stuff. What I have to say is both for the right and the left. Just now, they agree. When President Trump criticized a court ruling staying his executive order on asylum as coming from, quote, an Obama judge in the, quote, unfair Ninth Circuit, Chief Justice Roberts could stand no more. Quote, we do not have Obama judges or Trump judges, he wrote. What we have is an extraordinary group of dedicated judges doing their level best to do equal right to those appearing before them. That independent judiciary is something we should all be thankful for. President Trump hit back. Sorry, Chief Justice Roberts, he tweeted, but you do indeed have Obama judges. And if the Ninth Circuit was indeed an independent judiciary, why are so many cases opposing border security filed there? And why are a vast number of those cases overturned? Rhode Island Democratic Senator Sheldon Whitehouse, rated one of the most liberal members of Congress, agreed with the president, sort of. He said, in spite of my distaste for Trump's attacks on our judiciary, on this one, the facts are with Trump. Except, he said, that the facts show that Republican judicial appointees in general, and those on the Roberts Court in particular, quote, show no respect for precedent, federalism, originalism, or judicial restraint. So you see, the left and right agree. Judges are not independent. That is, they take sides, by which I mean judges are said to rule for reasons other than the law and the facts. Perhaps they have personal convictions that the country or state should take a different path, and judicial pronouncements on the law can lead the way. Perhaps they see themselves as gods in the temple of justice rather than priests, possessed by the very ambition President Jefferson was so afraid of. Or perhaps in the state systems, judges are afraid of the political clamor that can turn them out of office. But for whatever reason, lofty or lowly, judges are not seen as independent of the other two branches of their governments or from popular opinion and politics. They're seen as taking sides. Judges are not independent of criticism. President Clinton said, I support the independence of the federal judiciary. I do not believe that means that those of us who disagree with particular decisions should refrain from saying we disagree with them. By us, he meant the people, of course, and he was right about that. But for us, meaning the executive, especially the president, I think criticism of judicial decisions is different, as I will explain shortly. The First Amendment protects speech, even against judges, even when the speech is unfair and wrong. Criticizing public officials is a time-honored tradition in this country, and judges are not and should not be exempt. Nor are judges independent of the accountability all public officials owe the people for their stewardship of power. Importantly, for the judiciary, the measure of fidelity is different. The executive and the legislature must uphold the Constitution, of course, but they must also answer for representing their constituents, for shaping and effectuating the popular will. Judges have no constituencies. They account to the people for their adherence to the rule of law. When judges follow the law, even against the popular will of the time, actually especially against the popular will of the time, they have done their job. When judicial accountability is for fidelity to the rule of law, judicial accountability and judicial independence, if not congruent, are at least aligned. Independence satisfies accountability. Accountability rewards independence. But when accountability is measured by whether a judge decides cases the way people like, and what people like is different from what the law is, the pressure is on the judge to surrender independence and the law to popular will, to take sides. That pressure usually evidences itself in judicial selection and retention. For federal judges, retention is essentially off the table. Hamilton believed that life tenure for federal judges was essential to protect their independence. A judge could not be removed for an unpopular decision except by impeachment, which, as President Jefferson learned with Justice Chase's acquittal on all counts, was difficult. And so federal judicial accountability is focused on selection and confirmation. In 1916, President Woodrow Wilson nominated to the Supreme Court a strong supporter, a Boston lawyer in private practice, Republican turned Democrat, business lawyer turned rabid reformer, Louis Brandeis. Conservative Republicans, the Attorney General of the United States, and ABA presidents lined up to oppose the nomination. Their concerns were how he would rule, that he was a liberal, and who he was, Jewish. Years later, Justice William O. Douglas wrote, Brandeis was a militant crusader for social justice. He was dangerous because he was incorruptible, and the fears of the establishment were greater because Brandeis was the first Jew to be named to the court. Brandeis's nomination was so controversial, the Senate, for the first time in history, held a public hearing. The confirmation process lasted an unprecedented 4 months. It is impossible for us, accustomed as we are to confirmation consternation, to appreciate the upheaval in confirming Justice Brandeis. One newspaper editorialized, "The Supreme Court, by its very nature, must be a conservative body. It is the conservator of our institutions. It protects the people against the errors of their legislative servants. It is the defender of the Constitution itself. To place upon the Supreme Court judges who hold a different view, to supplant conservatism by radicalism, would be to undo the work of John Marshall and strip the Constitution of its defenses." The newspaper, the New York Times. Contemporaries thought the Brandeis nomination threatened an end to judicial independence. And now, 102 years later, many people think the same of the Kavanaugh nomination, both sides. Though the two nominees were very different, at a general level, the questions were the same, as they have been in many other confirmations. Who are the nominees personally, and how will they rule on cases? When judicial accountability turns on what side a judge is on whether a judge's decisions are or will be popular, that is when judicial independence is threatened. The judge must decide, often at some personal peril, whether to adhere to the rule of law or succumb to the pressure. Nominees almost always promise they will follow the law. They will be umpires, calling the balls and strikes. Skeptics accuse supporters of favoring the nominee because they think he will rule their way. Supporters accuse skeptics of opposing the nominee for the same reason. Does anybody in the hearing room really think the nominee will adhere to the rule of law, ignore his own predilections, ignore politics, and do equal right to all? In the often abstract and hypothetical, often accusatory and combative, sometimes kabuki-like dance, sometimes histrionic, and almost always contentious Senate confirmation hearings, the message is not lost on the American people. The judges will take sides, and it's important to know whose side they will take. Judges are not independent. The confirmation for federal judges influences the processes for retaining state judges in that the participants in both and the watching public come to believe that the real issue is not whether the judge will be fair, but whose side she will be on. In all but the 3 states where judges serve for life or until age 70, that issue can be revisited periodically in the retention process. In all but 8 states, judicial retention involves some kind of election. In a few states, those elections are partisan, as if the candidate were running for legislative office. Texas, as you've heard Tom say, is one of those states. If opposed, as they often are, judges and judicial candidates must campaign to win. To campaign, to take a message to voters, they must raise money, mostly from lawyers, but also from groups often bent on seeing judicial decisions go their way. And as the Supreme Court has told us, judges and candidates running for judicial office have the First Amendment right to speak out as freely as anyone on politics and even issues that may come before the court subject to recusal. The judge and the judicial candidate are thrust deeply into the political arena in those states. I've been elected to the Texas Supreme Court 6 times, more than anyone in history. In my 45 years as a lawyer, 38 of them on the bench, I have done all I could to oppose the partisan election of judges. Texas elects 1,884 of its 3,210 judges, all but the municipal judges. And despite limits on contributions to and expenditures by judges and judicial candidates, limits Tom Phillips and I pioneered voluntarily before they became law, the process can at times be freewheeling. Instances of proven influence on judges are rare, but lawyers and even judges themselves believe that raising money and running with partisan labels gives the appearance of outside influence. Partisan judicial elections are the exception nowadays. In the past 80 years, the desire to preserve judicial independence has driven efforts to reform the methods for selecting and retaining judges in the states. As a result, judges in roughly 2/3 of the states still face election to enter and remain in office, but the elections are either nonpartisan, with opponents having no partisan labels, or retention with no opponents, just a yes or no vote. Neither has eliminated threats to judicial independence. In 1986, Rose Bird, Chief Justice of the California Supreme Court, was not retained in office because of her perceived personal opposition to the death penalty. She had voted to overturn convictions in 64 of 64 death penalty cases that had come to the court. In 2010, 3 of the 5 justices of the Iowa Supreme Court, who had voted unanimously the year before to strike down the state's prohibition of gay marriage as unconstitutional, were not retained in office. Most Iowa voters opposed gay marriage. Over $1 million was spent to reject the justices who chose not to enter the political fray. Our hope, one later explained, was that the Bar Association and others would come to our aid, and they did, but not with the vigor and money that was required to counteract the emotionally laden and factually inaccurate television ads that ran incessantly for 3 months prior to the election. 2 years later, public opinion had changed. Most Iowans opposed a constitutional amendment prohibiting gay marriage. The Chief Justice, who had joined the court's gay marriage opinion, was retained. The almost inescapable conclusion is that the retention or non-retention of the Iowa justices depended on popular views of their decision in one case. In 2012, the 3 justices of the Florida Supreme Court up for retention that year were opposed as having, quote, undermined property rights, education rights, and fair elections. Specifically, opponents were upset over the court's decision to remove from the 2010 ballot a constitutional amendment challenging the individual mandate of the Affordable Care Act. The justices in Florida, unlike the justices in Iowa, fought back vigorously, assisted by the state bar, and they were retained. In 2014, retention of 3 justices of the Tennessee Supreme Court was opposed by the lieutenant governor, who called the justices, quote, soft on crime and, quote, anti-business. They too fought back, supported by lawyers who felt the entire profession was under attack, and they were retained. But their opponents claimed victory. They said any decision that they make going forward, they know they have conservative groups that will hold them accountable. Perhaps the most remarkable interbranch struggle in any state has been in Kansas for most of this decade. Repeated, organized efforts have been made to defeat the retention of justices of the Kansas Supreme Court over its decisions on abortion, the death penalty, public school finance, and administrative control of the court operations. At one point, the legislature threatened to defund the entire judiciary if any court held a particular statute unconstitutional. The Supreme Court did so anyway, and the legislature backed down. But the idea that judges should be punished for not deciding cases one way or another remains. For now, said one Kansas group that had opposed the judges, we can only hope the judges have learned a powerful lesson. Arkansas selects and retains judges in nonpartisan elections. Last year, an incumbent justice on the state Supreme Court was vigorously opposed by a nationally funded advocacy group reported to have spent over $1 million on a barrage of dark money ads to defeat her. She fought back and was nevertheless reelected. Now, there are very good reasons to change from the partisan election of judges to nonpartisan elections or to merit appointment with retention elections. But a 2012 empirical study convincingly concludes that the threat to judicial independence is not thereby reduced and may even be increased. The study writes, quote, retention elections create pressure for judges to cater to public opinion on hot-button issues that are salient to voters. Moreover, this pressure can be as great as that in contested elections. Now, I've given you a few high-profile examples of efforts to pressure state Supreme Court justices in the retention process. There are many others, but they are all a tiny fraction of the thousands of instances in which state judges have been elected and retained routinely, quietly. Even in the examples I have given, judges were most often retained. But my point is this: even when judges have survived political pressure, the belief that judges are, can be, or even should be independent is in doubt. Federal judicial confirmation proceedings and state judicial retention election campaigns, whether with partisan opponents, nonpartisan opponents, or no opponents, support statements by the executive, by legislators, advocacy groups, and the media that judges should answer not just for their adherence to the rule of law, but for whose side they're on. This view, threatens the separation of powers and the perceived integrity of what must absolutely be impartial decision-making. As Justice Brennan wrote in Northern Pipeline Construction Company versus Marathon Pipeline Company, the federal judiciary was designed by the framers to stand independent of the executive and legislature, to maintain the checks and balances of the constitutional structure, and also to be the guarantee of the process of adjudication itself remaining impartial. Justice Brennan, having come to the Supreme Court from the New Jersey state courts, would have said the same of state judiciaries. The independence of the judiciary, he said, must be jealously guarded. But not so much against external threat, at least at this point in our history. Raucous though the process can be sometimes, federal nominees are being confirmed at a fast pace, and the Senate promises to accelerate the process faster. Criticism of federal judges, even from President Trump and Senator Whitehouse, poses no threat to life tenure. And in all but a very few instances, state judges have been reelected or retained despite overwhelming opposition to particular decisions and vicious personal attacks. Measured by the number of judges obtaining or retaining office, criticism has not so much as dented judicial independence. But that's not the only measure of the threat. Of greater concern is how the federal confirmation process and state retention processes and their influence on an already sympathetic populace affect judges themselves. Are they more convinced that their personal convictions should trump the law? Are the pressures of today's politics forcing more state judges to yield to the temptation always to be looking over their shoulders for how a decision will be perceived? Even when some judges have won, have others, as opponents have said, learned their lesson? If only 1 in 1,000 people walking along a street is shot at, you still think about taking another street. As I have warned in my last 2 State of the Judiciary addresses to joint sessions of the Texas legislature, when partisan politics is the driving force and the political climate is as harsh as ours has become, judicial elections make judges more political, and judicial independence is the casualty. Make no mistake, I said, a judicial selection system that continues to sow the political wind will reap the whirlwind. So here's my argument. Criticism of judges in the federal confirmation process and in state retention elections insists that judges take sides. So why not? Go their way, lest you lose an election. Go the other way, following strong convictions and satisfying supporters. But one way or the other, take sides. The real threat, in my view, is not from without, but from within. The threat is not that judicial independence will be taken away, but that it will be surrendered. So what can be done to protect judicial independence from this internal threat? Well, first, judges must demonstrate, they must prove actually, that they are above the fray. Federal judges know they must not be non-political, but do they show it? Who's right? President Trump? That Ninth Circuit judges are biased against him in his cases? Senator Whitehouse? That Republican president's appointees have an agenda? Chief Justice Roberts? That there are no Trump judges or Obama judges, but only judges trying to do equal right by all. If Chief Justice Roberts isn't right, shouldn't he be? And shouldn't we insist that he is? Mustn't the judiciary distance itself from its critics and claim the higher ground? We need more outspoken examples. State judges must set their own example. The November partisan judicial election in Texas saw many Democratic judges swept into office as voters chose O'Rourke over Cruz for United States Senator. Cruz won, but hundreds of incumbent judges running as Republicans, having chosen the wrong party label, lost. Some newly elected judges said publicly that a Democratic judge would rule differently than a Republican judge. At least one very experienced appellate attorney, joining the appellate court in the sweep, told the press, quote, "Judges don't think like that." His message should win the day. Judges should approach decision-making with what Justice Scalia termed modesty, I would say humility, the idea that the judiciary is but one part of the government, that separation of powers works both ways, to keep the judiciary out of the other branches' affairs as well as the other branches out of the judiciary's, and that the judiciary should eschew the political fray when it can. Justice Scalia was criticized for not following his own advice, but regardless of whose side you take on that, the advice is sound. Whenever a case requires a court to wade into politically charged waters, the court should do so with reluctance rather than glee. And that should be front and center in the court's opinion. The hot button case requires the judge to write to convince, not merely to decide. The Texas Supreme Court has held the public school finance system unconstitutional 4 times, never encountering more than pro forma remonstrance from the legislature, although the first couple of times it seemed a little more than formal. We survived. One reason, I think, is that the court's opinions were so detailed, so carefully reasoned, so deeply grounded in authority, that it was hard to argue that the court was being political. Even the staunchest opponents of change had to concede the facts and the analysis of the constitutional issues. I won't criticize other court decisions here, but I will say the you're wrong, they're right opinion that dusts off serious arguments prompts criticism of the judiciary. An umpire who justifies his call because he's the umpire is not as well respected as the umpire who explains why any umpire would have made the same call. State judges still make policy decisions in defining the contours of the common law. Those decisions, too, must draw on history, address changed circumstances, balance competing interests, and reason carefully, and craft the common law to last. Common law decisions cannot merely be edicts and must recognize that legislatures can respond and choose differently. When attacked, the judiciary cannot effectively defend itself. Its self-interest in doing so calls its motives into doubt. Its resources for such a campaign are entirely inadequate. And self-defense necessarily draws the judiciary into the very political arena it is trying to avoid, as the Iowa justices believed. Even when judges have actively defended attacks on their independence, they have been effective only with the assistance of the profession. Judicial independence is not readily understood, especially in a culture as lacking in civics education courses as ours. The legal profession best knows and appreciates how essential to our democracy is the fair and impartial administration of the law by judges free of the influences of executives and legislators, popular opinion and politics, and even judges' own personal opinions. The burden of jealously guarding judicial independence, those are Justice Brennan's words, falls to the legal profession. The profession's efforts were probably most responsible for defending judges in Florida, Tennessee, and Kansas, though efforts fell short in Iowa. The American Board of Trial Advocates, comprised of trial lawyers on all sides of legal issues, plaintiffs and defendants, business and personal injury, all sides, has been especially active. The national organization has developed a protocol for responding to unfair criticism of judges for use by each regional chapter. The Texas chapter has a standing committee to ensure a strong, published response to personal attacks on judges and their integrity that threaten judicial independence. The most effective defense is always the one seemingly against interest, the defense of the judge with whose decision you disagree. The responsible lawyer can express disappointment in a ruling and vow to see it overturned without maligning the judge's integrity. That's the goal of the Texas ABOTA Protocol. Certainly, as President Clinton noted, people are perfectly free to criticize judicial decisions with which they disagree. But leaders in the executive and legislative branches have loud voices, augmented by the media's megaphone, especially social media's. The profession must be as effective in cautioning the public against public officials' denigrations of the third branch that, if effective, will deny people the protections of an independent judiciary. Once or twice each year, I am visited by judicial delegations from foreign countries, Europe, Africa, Southeast Asia, and elsewhere. One question is always asked: what happens when a judge's ruling is unpopular or goes against the government? The judge may be criticized, I say, but generally the profession and the people believe in and defend an independent judiciary. I was explaining this to a delegation from Iraq. One judge, a woman, sat quietly, her eyes filling with tears. Her colleague explained, while she has been on this trip, her father, also a judge in her hometown, was killed because of an unpopular ruling. I think that alone proves President Jefferson was wrong. But the prosecution never rests, and so neither can the defense. Public discourse today is intense, to say the least. The verbal brawl long ago abandoned the Marquess of Queensberry rules. Judicial independence should not be a casualty. The legal profession, and I think especially the Academy, must defend it, and judges must prove they deserve it. Thank you for your attention.
Thank you very much, Mr. Chief Justice, for a very important talk, and I'm very pleased that the NYU Law Review will be publishing it. We have time for a few questions, so if you have a question or comment, would you walk up to the mic and identify yourself? Professor McKenzie.
So I'm looking for tips, not the monetary kind, but you gave examples. You gave Iowa, Florida, Tennessee. What do you think made the difference in terms of the support given to the judiciary by the bar, the profession, the public more broadly in those different states, so that you had one outcome in Iowa but different outcomes in, say, Kansas and Florida? What do you, is it a single silver bullet? Is it a strategy? What made the difference?
I think it was a strategy. So, as I said, the Iowa judges decided that it was, it defeated their whole argument for them to try to defend themselves. They were trying to prove that they should be independent of this massive criticism. And you can't, I mean, you have to think about a campaign for president or a campaign for governor, something where there's just a massive amount of campaign ads day in and day out. People are hearing in the press, this is a bad judge because he voted this way in this case. Although sometimes, as it was in Florida, it's much more diffuse. These are bad judges because they're anti-American. I mean, it's almost that broad. They're anti-business. Well, what does that even mean exactly? But in the other states, the key that everybody will say to the judges retaining office was the organized bar saying, we put down our differences. Okay, the plaintiffs are fighting with the defense bar. and the business folks and the family lawyers don't get along, and all these different segments of the bar. And in a world that is as divided as ours is right here and now, this was a very powerful message by lawyers coming forward and saying, look, we represent different people. We don't agree with everything these judges have done. But make no mistake, this is an attack not on these judges, but on the judiciary itself, which is protecting you, and you need to see it for what it is. And then, you know, lawyers are very bad at making those kinds of arguments because they're too substantive. You've got to go get a media person to tell you that, you know, we got to fight fire with fire here. We can't, you know, we can't dress this up like a Supreme Court brief. We've got to really tell people what's at stake, and that's what they did. The judges helped them. We can talk about whether that's good or bad, but they felt like they had to. Florida was pretty clear victory. I think they won by more than 60% in Florida. Tennessee was a lot closer, but there was a lot going on in Tennessee at the time. So the real difference was in the organized bar saying, this is bad for the profession, it's bad for you as a taxpayer and a voter, and you ought to resist it. And they're not telling you the truth.
We have time for two more.
Sam.
Never mind, Sam. Well, Professor Zakharoff, then I'll take you.
Chief Justice Hecht, I hate to say this, but we've been talking about this issue for 30 years now.
Right.
Just about. And there's one thing that I think both of us would prefer a system of some kind of an appointment of judges and not election. But if you're going to have elections, I've always been torn, and I hear judges tell me both sides of this. And the divide is this. If you have partisan elections, at least you're running against somebody. And at least you're protected because most people are completely ignorant of the judicial candidates. And so it's low profile, and you're protected by a political party and a political establishment. If you're running in retention elections and you do something unpopular, any demagogic attack is just against you, and the population can just vote no. So I wonder where you've come to rest on that issue at this, because we've gone back and forth, as I recall, many, many times on this.
That's the 2012 study. They just did it on one issue, it was abortion. But they went through retention elections, and then they went through partisan elections. And the conclusion was that the retention elections did not improve the resilience of the judges, and in fact may have made them more vulnerable. Because it's exactly as you say, it's just too easy to single them out. And
Better to have an opponent.
it's better to have an opponent, but it's, you know, it's truly, according to this study, and I think it's probably right, it's better to have a party because the party diffuses the criticism. If you're attacking the judge, you're attacking the whole party. And so the party is going to stand up for you to some extent. But, you know, again, that kind of defeats the purpose of having independent judges, because if you're running with a partisan label, everybody says, well, you're on that side. I don't think that either one is a very good solution, but the study, which is a very thorough, empirical, data-driven study, shows that if you're looking to retention elections to solve this problem, it's probably not going to do it.
In the rear, would you come forward? In the rear. Come to the microphone. Come to the mic.
Your Honor, what I thought was missing was West Virginia.
Yes, well,
Other than the archaic argument that of Vox Populi, that historically in tradition we've elected judges, we're the only country in the world that elects judges. And it seems to me West Virginia in the last 20 years has become a veritable cesspool of corruption, partly because of the election process. And the Supreme Court reluctantly censored that through the decision saying that the failure to accuse of the corrupt judge was a denial of due process. But as Arthur Vanderbilt looks down upon you, he's the classic example by eliminating from the 1947 Constitution, when he was Chief Justice in New Jersey, New Jersey went in 10 years from the worst judiciary in the country to arguably continuing the best. So, other than tradition, what is the continuing virtue of elected judges?
Well, I obviously don't think there is any, because I've tried to, I've spoken against it every way we can. The governor of Texas is going to support this year, for the first time in the state's history, some sort of appointment system like several other states have. I left out West Virginia because they've fallen on such difficult times. Our friends in West Virginia, a couple of them have gone to prison, and West Virginia was I think it's the only state in the country where the judiciary wrote its own budget and the legislature could not do anything about it. Now, I'm pushing for that in Texas, but but we're not getting there very fast. It would, they were just lots of problems. But you're right about that. I think, but as Tom knows, we've been in this issue for a long time. The people want to know, they want to vote on their judges. They want to throw the bums out. Whenever you ask the people, are you for voting on anybody? They're for voting on, because they want to have some say over whether they retain office. But the practicality, as everybody knows, when you have in Houston, you have 70 or 80 judges on the ballot in any election, the lawyers don't even know who they are. And so I don't think it serves much purpose.
All right, on that note, please join me in thanking the Chief Justice again.